Ladies and gentlemen, let's start. Legal smart contracts. Today, Tony is going to moderate this roundtable. Please.
Thank you, Andrew. So thanks everyone for being here. I would encourage, I think, folks, if you wanted to move forwards, we can sort of make this a slightly more intimate discussion. But essentially today we have here four legal experts, variously involved also with advising in the cryptocurrency space, investors, hedge funds, regulators, even class actions. We have sort of perspective also from a academic perspective as well, because Wulf here is a professor of law as well at St. Thomas University in Minnesota, and I run the blockchain group at Stanford Law School, and we've just established the Stanford Journal for Blockchain Law and Policy. And again, part of the premise for what we're trying to do here with this panel is to talk a little bit about the intersection between a lot of the technical aspects, uncertainty, and affordances that smart contracts and distributed ledgers generally are providing within the future of work, the future of the economy, and also the future of the legal system, but also how those interrelate with existing jurisdictions, existing practices to enable legal certainty, both within the crypto space and I think more broadly, again, within the larger economy. The way we're going to structure this, to kick off, Wulf is going to just talk a little bit about his specific project, Samada, and then we're going to go around and sort of provide some commentary around that, and we're going to have some time, I think, for comments. I'd be very curious to understand, once we've given Wulf a chance to talk through his position, what are some of those sort of pressing legal queries that people have around, how to make smart legal contracts work properly, how those fit within the context of governance systems, and decentralized governance especially is one of those issues which sort of ties in with smart contracting frameworks in the same way as a sort of a terms of service applies within the context of the specific interactions within users in on a platform. And that obviously applies going forwards into the underlying legitimacy of a blockchain ecosystem. In a situation where the only thing where a user base is attached to and sort of staying involved with a particular blockchain ecosystem is the sort of ideology or the legitimacy of how that ecosystem is governed, governance and how you actually embed legitimacy and true sort of legal sort of certainty within your framework can be one of the only things that's going to prevent someone from forking your chain and running it yourself. So with that, I don't know if you guys, want to just give a quick introduction to yourselves as well, and then we'll hand off to Wulf.
Thank you. Hi everyone. Thibault Verbiest. I am a lawyer in Paris and in Brussels. I am partner with a law firm called DS Avocat, and I'm heading up the practice. We have a practice dedicated blockchain, a department dedicated blockchain and crypto finance. And so I've been specializing in blockchain regulations over the last 3 years. And I am advisor of the European Commission concerning crypto regulations as well.
My name is Alex Lindgren. I'm a partner with Lindgren, Oehm You, small firm with offices in New York, Los Angeles, and New Jersey. I work very heavily at this point with cryptocurrency-related firms, including family offices, hedge funds, and venture capital funds, as well as more recently on the issuer side. And as an aside, as he mentioned, we also do some advising for larger firms that are engaged in class action and consumer suits in the space as well. So we've had to think a little bit about the enforceability of smart contracts in California courts.
Okay. Do I need this? Okay, I'll take it. Hi guys, thanks for coming, thanks for your interest. I really thought we would just be talking among ourselves, so appreciate your coming, listening to this. Okay, so can crypto evolve with the existing legal infrastructure? In other words, is crypto compatible with what we're doing in law these days? I would say no. So let me be upfront about this. This will not work. And so Samada was born out of the assumption that it won't work. Whatever the Europeans are doing, Financial Task Force, whatever we're doing in this country with the SEC, ultimately crypto will necessitate an intra-crypto legal system. And I'll tell you why. That's 3 years ago. I started writing this article. The ABA accepted the article, even though the article really, at its core, is arguing that the ABA is no longer necessary. So American Bar Association, right? So, okay, so here's what I want to do. Just because this is about smart contracts, let's talk a little bit about smart contracts, what they are. I mean, you guys all know this. Just basic background conceptions here. Then lack of legal solutions as DLT evolution stoppers. So this is that core argument that it just won't work. We need something else. And what might that be? Well, we would suggest distributed jurisdiction as one way to think of this. And that can be done through reputation verification. Now, a lot of people in the room, to the extent that you've had the exposure, will say, okay, I don't want to talk to this guy anymore. Nobody has figured this out. They're not going to be the ones who figured this out either, okay? Why? Well, these systems are all Sybil attackable, yeah? So nobody has really done this in a way that is Sybil attack and majority attack resistant. We believe Samada is that. But there's certain issues that have to be dealt with. Yeah, for instance, one thing that we're experiencing is that it's very slow in terms of market acceptance. This has to grow organically. This cannot be done hush, hush, quick, a few solutions here and there. Yeah, this is, to get it right, to make it Sybil attack resistant, it has to evolve slowly. And that not everybody in the crypto space is happy with that, yeah, especially the investors. Okay, so smart contract, we all know, self-execution, self-enforcing, self-regulating, no intermediaries, all the buzzwords are up there. What is the problem? Well, we all know smart contracts have bugs. They're everywhere. Even the most basic smart contract, under 200 lines of code, right? So I teach coding for lawyers. We cannot assume that that code is solid. We can't. Yeah? Under 200 lines of code may have bugs, which we don't know. Yeah? So that's an inevitability at this point in crypto. And we all know what that means, what the outcomes of those bugs are. So parity is just one, there's all kinds of others. Yeah? Okay, the other big problem for business is we have this merciless mathematical precision in smart contract. Well, that's not how humans interact. Yeah? So, for instance, as a lawyer, interpreting intent, what did you actually try to do in the smart contract? Well, the smart contract as coded forces that, yeah? But we don't really know what the intention of the parties was. Yeah? And judges right now, they're really struggling with this. Yeah? And I'll get to that in a sec. Unanticipated eventualities, and what if a party only fulfills one portion of the contract? Yeah? What about those rogue wallets that are out there, where we know they have been betraying the intent between the two parties? Yeah? What are we going to do about those? Okay, so this doesn't come out very well, but so we all know there are huge problems in DLT, right? So performance, I mean, EOS has really, I think they have nailed that at this point, not completely because there are all kinds of issues, but in terms of scalability, it seems to me that EOS is the way forward at this point. So anybody who's concerned about electricity consumption and so forth, we can talk about the ins and outs, but EOS is one way to deal with this. But, and they're open about this, they're very open about this, governance, not so much. Yeah, there's some issues with appointing 21 people to run the show. Yeah, in terms of decentralized governance solutions. Yeah, there are of course all kinds of other issues that we can talk about. But what I'm trying to say here is law is one of the most important issues. The governance of the blockchain is really, and Tony and I just talked about this. The academics are now picking up on this. Yeah, so slowly we see more and more publications. So if we look about DLT adoption blockers, scalability should be pretty much handled, security, usability, there are quite a few issues here. Of course, folks will argue, well, not every consensus algorithm has to fulfill the same needs. Hey, how are you? And so, but blockchain governance hasn't been really figured out, and legal certainty. Yeah, so if we are doing things on Zcash and Monero, there just isn't any way for the existing legal infrastructure to interface with that. Yeah, so let's take one quick step, and I'll end right away. I'll get out of your way. So let's look and compare a traditional internet transaction with a crypto transaction, just to see the legal implications, right? So what do we have? In a traditional internet transaction, we know the counterparties. They know each other, they know of each other, yeah? IP addresses are known, payment details are known, credit card details are known. It's traceable. We can exercise what in law is called in personam jurisdiction. A judge can say, this person betrayed the other person in this jurisdiction, therefore I'm exercising authority over this person in my courtroom, and that person has to show presence and deal with the legal repercussions of his or her actions in personam jurisdiction. We do not have that in crypto. We just don't. If you use a Monero or Zcash transaction with additional encryption levels, even with a traditional regular encryption method, it would be near impossible for a judge to, let's assume they can allocate all the resources that are needed to find that person. MasterCard is experimenting with tracing measures with AI, and they got far, but nobody can claim at this point to be able to trace Monero and Zcash type transactions. So that means in personam jurisdiction, no, absolutely not, doesn't exist. That means the courts are out. They cannot interface with crypto. These remedies that everybody needs, including people in crypto, G and I just had this discussion last night, they're not available in crypto. I don't know how many people in the room here were defrauded or lost money in crypto. Show of hands, anybody? Nobody? Terrible stuff, yeah, that is happening. Okay, so the more exposure you have, the more you are exposed to the lack of legal remedies in crypto. So what are we going to do? The courts are out. They can't give you legal certainty. So our approach, and this was published 2 years ago by the ABA, if I may add that, is we need some form of, I'm going through this really quickly, distributed jurisdiction. So what does that mean? Well, it has to be a jurisdiction that exists with legal solutions within the technology itself. Our estimation is that we can facilitate that through reputation verification in decentralized autonomous systems. That's what Samada does. I'll stop here.
So I think our panel members, myself included, might take a few issues with some of those claims that you were making.
You should.
So the first thing that the current legal system is not compatible with crypto, I think, in the context, for example, of establishing binding arbitration clauses within a sort of a governance framework, that's one of those methodologies that has been sort of approached in terms of this notion of private law and private contracting systems. And I don't know if Alex, did you want to sort of jump in on that?
Yeah, I mean, I think in the long run, the framework that Professor Kaal just laid out is accurate in the sense that there are some long-run issues in terms of interjurisdictional compatibility. That said, of the Monero or Zcash, I forget which one I was looking at, it's something like 2% of the actual transactions are scrambled, right, in the sense that they're non-traceable. We're suing or advising on lawsuits against probably a dozen different entities that on crypto legal smart contract transactions, because as a practical matter, very, very, very few transactions don't have some touch point to drag it back into the normal legal world. I will say that for now, where we seem to be is an intermediary phase, right? Because we don't have robust dispute resolution systems, and so you have to call what you might call like a court stack on top of your smart contracts, right? Smart contracts I tend to view not, there's this whole Codo's law thing, please dismiss that from your heads. Smart contracts are well named, they're like contracts, they're private law, they're private agreements between people. if you opt into a scrambled transaction on Zcash, I would argue that you are consenting to basically no remedy. But beyond that, you are probably best served by having some paper that underlies the transaction, and most of the transactions I run into do. Two, it is not as hard, I think, as it's sometimes made out to be to track down counterparties and get them into a court somewhere. Now, it does
think about the
occasionally
resources that are involved in getting that done.
Sure.
As someone who
And talk about
so-
judicial overload.
Yeah.
Right?
no, it's
And
a huge problem.
cost. It's not sustainable. I'm sorry, it just isn't.
So I think we're getting into sort of like the nuance of the absolute position, which is like there's no sort of interface.
Conversation starter, yeah.
It's a conversation starter. So one of the things that we were talking about is this notion that what on-chain solutions provide, which are sort of the conventional, what we just call straight up smart contracts. It's the whole contract is encoded, and you're sort of like basically relying upon, especially if it's shielded, you're just relying basically upon the code to enable what you can do, and that's incredibly efficient. It's like one of the main reasons why you want to do that is it enables access to the kinds of enforcement and remedies that the conventional legal system has methodologies to prevent you getting access. So there's frameworks such as consideration within the context of the sort of conventional legal contract law, which is essentially designed to provide a sort of like a de minimis, like a minimum level. Like if this contract isn't worth that much, if there's no real consideration, we're not as a court system going to bother, trying to enforce this for you. But that's something that is very much, you don't need a consideration within the context of just an encoded smart contract, because it doesn't need to be a fully enforceable legal contract.
Yeah, you also, I think one of the best things at this stage that they're very useful for is there's a lot of contractual agreements that are very simple, right? They're escrow agreements. They're X pays, I pay you X to receive Y. And it's a lot more efficient to run that through a smart contract that's self-executing than to have to run through an escrow agent or through an intermediary pay system. And that I think is one of the most valuable current applications. I think it's also the least problematic in the long run.
But now think about complex smart contracts with multi-million-dollar amounts that are fully decentralized and encrypted.
So I think
we have no solution for that.
Well, this is where this integration with the existing justice system is most important. And so, speaking from a enterprise company perspective, so one of the organizations we work with at Stanford is called the Open Identity Foundation. We've set up a series of workshops engaging with regulators and lawyers all around the world called the Blockchain Identity Trust and Governance Workshops, and essentially that's bringing the approach of enterprise companies like a Microsoft, a Google, a Salesforce, and who are looking to now, originally they engaged around digital identity, they established sort of these primary standards around how digital identity works. Now they're looking to do something similar with respect to their distributed ledger and blockchain implementations, and it's their reluctance, as you said, the biggest barrier to their adoption of a lot of these technologies right now is the legal certainty, and it's their legal teams who are holding that back. And so I think one of the, takeaways for any of you who are developing smart contract frameworks is when it starts approaching the level of sort of enterprise company level values and amounts, your legal teams are going to want to dig in on actually how this not only gets enforced on-chain, but potentially if there are sort of larger disputes in play, how are you mitigating and managing the risk around some of those larger transactions? And I think, this is certainly something that will be interesting going forwards in terms of an education
code.
So why do enterprises want in? Well, they want in because of the immutability, and I'm using buzzwords now, but they want in because of the immutability, the solutions that they can build on it, and the fact that you have almost zero transaction costs. Yeah? The reason why they're not coming in and why they're all struggling with this technology is the lack of legal certainty. They just don't know. Now, there are solutions, and we see more court cases being decided. But let me tell you this. When I did this research, I had a law professor, we have access to all the databases. So the ABA made me do a search, all federal, all state, US databases, to legitimize my claim. Guess how many hits we got for the following keywords: Bitcoin, Ethereum, smart contract. Total, billions of cases. Any case in history. We got 7 cases 5 months ago in dicta, not on point. In dicta, meaning they're not directly on point decided, the cases. Yeah. So I'd love to hear more about the European perspective on this, but there is nothing out there, despite the millions of smart contracts that are being executed. Now, you guys all know the Ethereum and transaction exponential growth charts, right? Now think about what's going to happen with EOS when EOS takes over at 0 transaction fees and scale and as a scalable blockchain. Yeah, and we have 0 legal solutions at this point. Yeah.
I'm speaking more from a practical point of view, and as a lawyer, and some of my clients were concerned about the validity of the smart contract they were setting up, and so we try to provide some legal assessment, which is not easy, as you can imagine, because we have no case law, no background, you know, and no one can guarantee anything. But our assessment was pretty optimistic in a way, because as long as we know who the signatories are of the smart contract, who the parties involved in transactions are, which is not necessarily the case all the time, we all know it, but as long as we know who are involved in the transaction, we believe that we have a principle in Europe, which is set out in a regulation that we call EIDAS regulation, and which is the equivalent in the United States of the e-Sign Act. And if I'm not mistaken, you have exactly the same principle in the e-Sign Act, which is a principle of receivability of any electronic documents as an evidence for the court. So the fact that you show up before a judge, a court, with an electronic document, that fact is not enough as such for the judge to say, no, I don't want to just to have a look at it because that's something I don't know, it's electronic, I don't understand anything about what you are showing me. Blockchain, what does it mean, you know? Yeah, okay, but that's electronic evidence, so you have to examine it. You have to examine it. And so we have at least that certainty that based on that regulation, European regulation, or the e-Sign Act in the United States, if one day we have to show up before a judge saying, oh, okay, we have there a blockchain with a smart contract on top of it, and which generates some binding agreements between parties. I'm going to explain later on how it's possible, but you know, can I just explain to you, yes, okay, it's reasonable. No, you have to convince the judge that what you are doing with that blockchain and smart contracts is reliable enough to create the rights and obligations that smart contract is supposed to produce, right? And then you are in a difficult situation, because the only way we have in Europe, same in the United States, in the only certain way we have to convince a judge that that given smart contract or online contract is binding is when you use what we call a qualified certificate, which is when you sign the document, you sign it with an electronic certificate, which is delivered by a third party, and blockchains normally don't like third parties, and so it's because it's centralized. So you have a third party which is called a notification authority, and that qualified certificate is like an ID, which is linked to the parties involved in transaction, and that works. But there are some situations where electronic certificates were linked to a blockchain or a smart contract. It's possible. It's possible. For instance, Visa and DocuSign are testing on Google Car the possibility to e-sign a smart contract for a Google Car. So it's possible. You just have to use an API between the KPI of the authority, the third party, and the blockchain. Might work. But in most cases, you don't use any qualified certificates, electronic certificates provided by a third party, because it's exactly the very contradiction of a blockchain. And now, assuming you don't use that, and you have just a smart contract, you have the principle of, okay, it's receivable. You cannot reject it just because it's a smart contract. Then what if the parties are not identified through real names, which is the case for most smart contracts on public blockchain? Did you understand that a smart contract on public blockchain is there forever? Do you know that? You know that? The smart contract, once it is launched on a public blockchain, is there forever. As long as miners continue to process it, it's there forever. So there is no way to change it.
You can have it on a second layer sidechain or something, right? And just have the hash of the smart contract on the blockchain itself. So it's not like it's there.
But just
but let's say you're right. Let's say the judge takes it. I struggle with that, but let's say the judge takes it. Now you have 1,000 lines of code, complex smart contract. How is the judge going to decide what the intent of the parties was?
Yeah, but
so this is okay.
Blessed be California and its extremely flexible law. So start with, there we go. Start with the fact that at least in California, the digital record, pseudonymous digital signature on any transaction is going. That's good. That's good enough. And as a matter of fact, if you demonstrate control over one of the two counterparties, right, in a given transaction, that's enough to get you in court. Here's where the trick comes in. You're right. There's this whole problem of identifying the counterparty, dragging them into court, which is why we have John Doe's. And so as a practical matter, here's how this is playing out. It gets into court, and I will say that the courts are, I think, alive to the fact that this is a problem, which is why we've been asked to speak to. We're actually supposed to give the California Court Translators Association a speech on some of these terminologies so they can translate it, right? But as a practical matter, what ends up happening is they recognize the contract, and then because there's no integration clause, they just look outside. Right, and so what you have to, for every, as of right now, at least in California, every smart contract, because we don't know how to write an integration clause, or at least I don't, which is a clause that says you can't look sort of outside the document, right, for indicia as to the intent. Right, so what ends up happening is, like most contractual disputes in California, which, to be honest, tend to get thrown to a jury more often than in other states, this spins out into a typical contract dispute, and usually there's a John Doe on the other side of the transaction, and if there's enough money, you spend the money to go track it down. Otherwise, judgment gets entered, and it lives there until you can identify the counterparty. But it's not a very elegant, it's not a long-term or an elegant solution, but what is it as a practical matter is the judges don't, at least the ones when we've spoken to them or in California, they don't see any problem with recognizing these cases. They're just like, okay, so you John Doe the defendants, you prove your ownership of the ID, and then there's no integration clause, so we just look at the course of transaction. Okay, great. That's pretty much how it's being done. It's being looked at like any other, and as a matter of fact, to the degree that there is precedent, it's looking back to bearer instrument litigation. So this is back it used to be you could sell shares to companies that could be just traded around, and if you owned it, you physically held it, you owned it. They're not legal in most places anymore, but is that
the right precedent for smart contracts?
I'm not sure it is, but it is. I can't speak to what we should.
We're talking about 60-year-old law.
Yeah, very old law. And so, as a practical matter, that's what they're looking to. On the other hand, we're looking to the Howey test, which is even older for securities laws. So, what are you going to do?
So, one thing I want to just put to you, all three of you, is this notion of lawyers who understand scaling, right? A big part of the promise of smart contracts, smart legal contracts, blockchain infrastructure, and open source generally is the idea that you can take something that has been successfully used, fork it, and then scale its use. Do you see lawyers understanding the potential of that for, again, some of these efficiency gains and some of the ways that these sort of risk management frameworks to make more fairer, efficient markets and commons work? Or do you think we've got a little bit of time yet to come till that starts happening?
I think we have a lot of time until lawyers really get to a point where they can interact with the technology. So I teach coding for lawyers, sorry.
Sorry, yeah.
As you said, today most smart contracts are very basic contracts, right? very basic. It's a escrow mechanism, which are very basic. If then, if something happens, then the smart contract will release tokens. Most of the time it works like this. So it's no big deal, The only thing we have to do as lawyers is to make sure that there is a link between the smart contract and some terms and conditions. And for instance, using dual integration, which something which already exists, which is not very complicated to do, is you create a reciprocal hash in both the smart contract and the terms and conditions that you put on the blockchain, so that they are both, linked in an immutable way. And that's the so-called dual integration. By the way, EOS is working on the same principle. And they put a constitution in the blockchain itself so that every transaction has the hash of the constitution inside, right? So that everyone is bound by the constitution on the terms and conditions when using the EOS blockchain, right? And so it's not very complicated in a way, even for lawyers, it's possible to understand that, right? And no, the question is, and it's not science fiction, is one day I would like to advise a DAO, Distributed Autonomous Organization, which is really autonomous, legally speaking. That's something I would be very excited to advise one day, because let's take Malta as an example. Malta is a small European country that you might know, and Malta, they have a new legislation, and which makes possible to approve. There is a new authority in Malta, and which will be able to approve, legally speaking, to approve DAO and give them a legal personality. And let's take an example that you will all understand. Let's imagine that the Google car is not just autonomous in terms of self-driving, but also autonomous in legal terms, so that the Google car will pay its own debts and will receive payments for car sharing. The Google car will have its own wallet with tokens and will pay parking tickets with its own wallet, will pay insurance policies, etc., with its own wallet. So we'll have a total legal autonomy. And in Malta, they have the legislation now to say, okay, this is like a company, actually. The DI will become like a company. A company is a fiction. A company it's a legal fiction. We have decided, a legislator one day, that's what in the Netherlands 4 centuries ago, invented companies, It's a pure fiction. It's like, the divine gods in the tomb of the ancient Egyptians,
A fiction
it's
that the government has control over.
Yeah.
Yes.
But, and that's something which is really interesting.
So I want to pick up off your enthusiasm and basically disagree with you, Wulf, and say that I feel like this is an absolutely transformational moment in the future of what lawyers can be capable of. And I think that it's not going to be decades or even several years, but we're going to see within the space of maybe the next 12 to 18 months a pretty fundamental transformation in how lawyers who actually engage with these kinds of technologies are going to be the ones that survive. The ones that
fully agree. Fully agree.
I agree, but if that's the case and it happens in just a couple of years, then you are going to see very few attorneys left. Because right now, I'd say one of the biggest barriers to this sector is that on a very fundamental level, most of our profession, and I accept the people sitting here, do not understand. I mean, they don't really understand what this technology is.
And that was my comment, because
fair enough.
The power is not with the young ones who are learning smart contracting and legal solutions in smart contracting. The power in law, let's be very real about this, is with the baby boomers. And until they're moving on this, and some are willing to slowly, but until they are, things are going to be very, very slow.
Well, I think this is how you will change this, because it doesn't need to be that way. But I was just engaging, I was just talking to one of the top law firms in London. They're an international law firm, and they have a legal innovation, and in many cases, who has been tasked with focusing on blockchain regulation and policy in every single one of their groups. So they split between 25 different groups, and now they have they have a person in each, and they have a sort of central lab of sort of 20-something people that is focusing just on legal innovation and in particular smart contracts and blockchain. And so the other thing about it is that lawyers, they're herd animals, right? And so they look at a Stanford, like you were saying.
Precedent. It's all about precedent.
And they look at a major law firm and someone's making that move. And so I think in the context of this discussion, one of the key takeaways I wanted to leave with you is if you have a lawyer who's being obstructive, there are other lawyers out there who are willing to be creative and engage within the frameworks of some of the more interesting approaches that you're developing. Because again, to the point, law is one big fiction. It was all made up in the first place. And for those of you who feel like the law and the legal system as it is right now is some sort of like immovable stone or rock-like interface, it isn't. And this is one of those spaces where we're seeing a huge amount of fluidity, a huge amount of creativity. And there are those of us, present company included, I think, who are very bullish about that and who know many, many lawyers who can engage around some of these more creative
we have
approaches.
to really put into perspective your role in this as well. So just for the audience, so Tony's role at Stanford and with the journal, that for my profession, for the legal profession, that is a huge signal. So the academy is all of a sudden waking up, whoa, Stanford has a journal on blockchain policy. The signal that sent, I really want to commend your work in this, is enormous. So hopefully we can mobilize the baby boomer generation with that, and I think that's again, the signal cannot be underestimated.
Yeah, and I'm actually going to second that because we recently put out an article with another journal at Stanford, and I'll be honest, when I went looking for guidance, maybe a year or so ago when we started looking at this space, I ran into a couple of Wulf's articles, and that's it. That's pretty much the only thing useful I found in the entire sector. So we ended up doing the analysis ourselves, wrote it up, got published, it was wonderful. But the legal community really needs to start thinking hard about this. It needs leadership from the academy. And I want to commend the Stanford for launching a new journal for this, because I'm hopeful that it will encourage the academy to lead the lawyers' herd towards interfacing with the technology more.
Thanks, guys. I want to open it up to questions now because we've got about 5-10 minutes. So does anybody have any burning questions? Madam.
Hi, please forgive my voice. I've been speaking so much that I have lost it. Tanya Evans. I'm a professor of law at the University of New Hampshire School of Law and with the Franklin Pierce Center for Intellectual Property. And I agree with you that the academy needs to take the academy more broadly, but in particular the legal academy, to focus on these issues. But I am heartened a bit by some of the projects out there making some headway. We know that the law is notoriously slow moving forward, and the training of lawyers really needs to be, the whole way that we approach it needs to change. I'm a recent addition to the Accord Project's IP working group. We really are working to grapple with what are our existing contracts and how do we reduce to ones and zeros the things that can be reasonably objectified, and all those other things like waiver or best interests of the parties or best efforts that don't lend themselves well to reducing to code, that we still work as problem solvers on the front end, but we can farm out to things that are self-executing agreements, the things that are causing friction and not serving clients well. So I hear everything that you're saying and I agree, but I do think that there's a move for the early adopters in the legal academy, which is usually 10 to 20 years after technology has already taken off. We don't have that time with blockchain and distributed ledger technology. So it's more of a comment than a question to speak to what some of the things you've mentioned.
Thank you, Tanya. I just wanted to reference the Accord project, which you bring up, Tanya. So I was just on a panel with Dan Selman, who's the CTO, chair of the technology working group of the Accord project. And the Accord project is it's a standards body. It's a non-profit foundation established by one of the legal technology companies that are sort of burgeoning in the space. But again, it's designed to try and create a series of best practices around what smart contracts need to involve to make them more sort of legal in a sense. And some of that is around this notion of sort of trusted identifiers for both counterparties, but also computations. What IoT device are you using? How do you know that IoT device is what it says it is? Because to the extent that that's feeding into some warranty or representation within your contract, then you need to know, there's this whole notion of know your machine. alongside Know Your Customer. And so, as we start to, build out computational law frameworks, there are going to be more and more standards that you'll want your legal teams to be aware of, and hopefully we'll be able to rising tide lifting all boats, so to speak. So a question just behind you, Tanya. Yeah.
Yeah, so it's a quick question. So, I don't know, the way I think of blockchain, at least public blockchain, it's digital sovereign land. Like as this gentleman said, EOS is a digital sovereign land. They have their own constitution. Lawyers are actually obsolete in that environment because they're writing their own laws, right? So you can't go in and claim that, well, I'm from Malta or I'm from Europe, I'm going to impose my legal.
So we can get into really deep philosophical conversations about
Right.
sources of law afterwards, right?
Right.
But within the current framework, and this is a very broad misconception in the crypto community, jurisdiction has very little to do with where you are or what you're doing. It has more to do with who you are interacting with and where they live. And as a rule, large states will not allow their citizens to be interacted with without asserting jurisdiction. So you need to view the agreements, these constitutions and so forth, on public blockchains as essentially collective private agreements. And that the sovereignty, the individual national sovereignty of each participant in the blockchain still adheres, right? By signing up to use EOS, I am not abdicating my American or my Italian citizenships. And by the same token, by an EOS user, say, putting itself out to Italy or to the United States and availing me as a customer or as a counterparty is willfully submitting itself to the jurisdiction of those countries by seeking to interact with those populations.
So you forgot it. Actually, you stopped. I was, further part of my question, before you interrupt me, was that how would you take a particular, let's say it's US law, right? You're trying to apply some criminal law or civil law in a decentralized network where you're trying to interact with a certain individual who's interacted with the chain on maybe some, whatever the formality is that how would you apply it? Literally it's, if for example, let's say there is this, I don't know if you know about EOS, the 21 block producers who provide infrastructure to the network. And assume that you go after the one block producer who's in the US, who is running that particular infrastructure. Where's the head? Who will you go after? That's my question.
Yeah, I think it would need more specificity than that. In other words, the presence of a node operator in the US probably isn't that relevant, actually. But as a practical matter, if you've got a dispute, right, it's going to run through traditional legal analysis on choice of law, choice of jurisdiction. It's going to be viewed as any other set of private agreements or interactions, and it's going to get adjudicated in that way.
I want to just, I think, get to one of the points that you're trying to make, I think, which is, in certain situations, it is down to a choice as well, though. If you're choosing to interact with someone who is anonymous and that you don't have any real sort of framework, to sort of hang any potential enforcement action on, that's a kind of risk that you're taking on as a counterparty in a private agreement context. And maybe from the fact that it isn't probably worth that much, it's not actually worth you taking the additional steps to get that additional legal certainty to be able to enforce it in a legally certain way in traditional jurisdictions. It might just be a few dollars or something here and there. And so anonymity is fine, and you just want to get it going. So it's always somewhat a choice, and part of, I think, the opportunity here is that you're sort of increasing that level of choice around how you transact and how you make these agreements, some of which, when there's more risk involved, you will want to have that additional legal certainty. But part of the opportunity with all of these technologies is you've got alternative ways of managing risk and mitigating risk and sort of taking the choice yourself, not to avail yourself of that sort of broader, fuller sort of jurisdictional framework.
So before I ask my question, I just want to comment really briefly on that. Please, please, please hire competent counsel before trying to run a EOS block producer. EOS is particularly centralized and could potentially expose block producers to way more liability than Bitcoin miners or Ethereum miners or anything like that. EOS is far from a decentralized system and is in fact just a normal bank. But
Can you expound on the possible liability, please?
Oh yeah, absolutely. So EOS block producers are chosen by voting from the proof of stake from the actual EOS tokens that were issued by a group of mostly Americans, and mostly resident in America, to investors all over the world, nominally not to Americans, but I know many Americans that have somehow through their cunning methods found ways to buy them. And how it works is they vote in the same method that a shareholder would vote normally, through an open voting process to elect block producers, which are effectively a board of directors, and those block producers get to make unilateral and absolute decisions about what gets implemented into the record, which are effectively.
And so, who gets sued if that decision backfires? That's the question.
My answer is that given that they haven't registered this offering of securities in this scheme that's run by this board, 21 board members get sued.
I'm going to go one further and say that the lack of registration of their securities offerings is probably the least of their liability concerns.
Probably true. But anyway,
like
my point is that you don't want to be an EOS block producer. It seems like a way to get. Yeah, but there are boards of directors that do that too.
Ryan, do you want to ask your question?
But
now?
you
Sorry,
can
I gotta move
trace
this
the
on a bit.
decision, G,
Sure.
right?
All
and
I'm saying.
Yeah. Can we take?
Okay, sorry.
Can we take
I'll
this
stop
discussion
talking about
offline?
EOS.
Ryan, go on to your question.
I think we had other questions on this side of the room.
Okay, so
starting
let me
right there.
ask a quick question that's not about EOS.
Final two questions, because I'd like the lady just behind you to be able to ask that question as well.
Okay.
So you first, Ryan.
Okay, I'll go first. So the question is, for attorneys that are interested in getting this industry I think now has more per capita attorneys than banking does. What would you suggest that they study and get involved with besides the excellent journal from Stanford? For attorneys that would like to get involved in this industry, what resources exist for them to become specialists in this area of law besides the excellent
I think
journal?
everyone on this panel has written some excellent stuff that they should start with reading. But
I want to reference the Accord white paper that Tanya brought up.
Just be careful. There's some people out there who are claiming to be expert because they've written one piece, and let's just say that's not enough.
So, just behind you, thank you.
Okay, hopefully this isn't too much down the rabbit hole, but I'm just kind of curious, when you look at some of the smart contracts that, that it's basically automatically executing code, and then some of them actually relate to other smart contracts. And so how, as lawyers, when you're advising, how do you kind of think about kind of the game theory, the unintended consequences, second and third order effects when you're advising your clients?
So, as a former outsourcing lawyer, one of the things that we had to deal with sort of pre-blockchain and everything is just the whole nature of multi-party sort of system governance, where you have responsibilities and you sort of have nested hierarchies of contracts. And something that I think was mentioned in a previous panel was the notion of you've got sort of legislation in Europe where you've got sort of national legislation, European legislation. So this is a concept that many lawyers are already very, very familiar with, which is the notion that sort of referencing out to different sort of hierarchies and levels of legal governance. So I think there's again, this is somewhat a theme, but there isn't necessarily anything radically new from a theoretical concept, but practically there's a lot of additional affordances as to how this can be done in a much more efficient, transparent, monitorable way. And just referencing your point about game theory, I'd point you to Eleanor Ostrom's work around co-managing common pool resources. And if you think about common pool resources, they're actually common pool risks. There's another way of framing it. And so some of those design principles speak to the game theoretic dynamics as to how we manage markets and commons better. And if we're thinking about the affordances of what smart contracts can do with respect to each of those principles, it gets very, very interesting and exciting with respect to some of those game theoretic principles.
Okay, thank you very much. Thank you very much for the very interesting discussion. Let's thank our speakers for it. Let's applaud.